Hello. Yes, ma'am. Ma'am, once you open the link already sent by me, I think. Yes, yes, that's the only link, ma'am. No, no, No. It would be started by then, and if we can try it right now, so that we will be able to access to the things. It's already been accessed with the YouTube by me. Chrome is better. Okay, ma'am.
Yes, Siddhi, can you hear me?
Yes, sir, I can hear you.
And
Please.
can you see me?
Hmm.
See about YouTube. Actually, it's saying live on YouTube, but I don't know whether it's actually live on YouTube or not.
Just a second. Sir, YouTube पे what should I type? What link should I?
Prevention of Money Laundering Act, I think it would directly come. Or there is a link if you are seeing on this live on YouTube. Are you able to see some link on this?
सर YouTube मैंने ऐप खोला हुआ है बट उसमें कोई लिंक नहीं है फॉर लाइव एनीथिंग जस्ट अ सेकंड लेट
अच्छा,
मी
ये जूम वाले पे देख, कोई लाइव कुछ दिखा रहा है अपने जूम वाले पे।
हाँ, एक स्क्रीन पे आ रहा है लाइव ऑन यूट्यूब करके ऑप्शन।
पर इसको करियो क्लिक।
कॉपी स्ट्रीमिंग लिंक, एक सेकेंड आप लोग को। सर वो ना लिंक आ रहा है और लिंक से आपको फिर वो खोलना पड़ रहा है, तो वो लिंक अगर मैं खोल रही हूँ तो वो सेम। हेलो हेलो नितेश सर आप म्यूट पर हो। हेलो नितेश सर, हेलो हेलो सर, आई कांट सी यू नाउ। हेलो नितेश सर, हेलो yes sir, now I can see you. Sir, you are still showing on mute, if you can hear me. Hello Nitish, can you hear?
Yes, we all can see the slides.
लोग मुड़ो, अच्छा मुड़ो। I need the agreement because agreement is also found, right? I need the
Is Anu
agreement
ma'am
of
there?
Satyavati,
Is
and
Anu
I
ma'am
need
there?
also, hello, agreement of Satyavati, and I need the previous
Yes.
communication. I am not.
No, it's already opened. I've admitted.
I'm not able to. I'm not able to kind of. I don't
It's
know. I'm
already open.
typing. I'm
Everybody
not
can
getting
see
it.
it.
So
It's
can you
working.
re-forward it to me, please? हाँ और जो उसके पॉइंट्स है ना रैंडमली
Everybody
नहीं
is
इंक्लूड
there on the
करना
link.
बिकॉज दोस कैन गो अगेंस्ट अस हाँ क्या मानसी बात करें
Yes. You connect me?
Is Anu ma'am on?
Yes.
Is Anu ma'am there?
Yes, I'm there.
Okay. So Anu ma'am, I think we can from here now start with the today's webinar and start with ma'am's introduction. And ma'am is already there.
No, I'm just simply going to welcome her.
Okay. Okay. Thank you so much.
It is my pleasure. Are you on air?
Yes.
Should I start?
Yes. Yes, please, ma'am.
Yes. It is my pleasure to welcome Ms. Geeta Luthra, Senior Advocate, to deliver her lecture on PMLA. I am sure that the participants are equally thrilled. So without much ado, I would like to invite and welcome Ms. Geeta Luthra, Senior Advocate, Delhi High Court. Ma'am, over to you, ma'am. Geeta Luthra, Senior Advocate. Let's have it from her, ma'am.
Thank you. Discussion on any aspect of law would be complete without discussing what are the principles of law. Why do we look at what is he or she is proved guilty. This is a common law principle, and all our jurisprudence is based on this. The second aspect on which our criminal jurisprudence is based is that the burden of proof, that there is a presumption of innocence and a burden of proof is on the prosecution. The presumption of innocence is also a fundamental of criminal jurisprudence. So this one, a person is innocent unless proved guilty, that there is a basic principle, the presumption, the burden of proof is on the prosecution. These are aspects which, to a certain extent, have been turned on their head under the Prevention of Money Laundering Act. So we have to see how these principles have evolved and whether there is a need to turn them on their head. To what extent should the act have been amended time and again? And what is the laudatory object of the act, which necessitates that we, in fact, turn these principles around, even though in one of the judgments of the Supreme Court in 2018, there have been certain pronouncements which have been in favor of the citizen. And with this regard, I would like to quote Article 22 of the Constitution of India, which we have to look at when we look at the Prevention of Money Laundering Act. Article 21, protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. 22, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and be defended by a legal practitioner of his choice. So these are some fundamentals which, when we look at various provisions of the Prevention of Money Laundering Act, in short, the PMLA, we'll have to look at, are they satisfying the constitutional mandate of Article 21 and 22? There have been a number of pronouncements of the courts, and these have been in various proceedings, including in habeas corpus proceedings, where the accused have come before the court and said, we haven't been given our grounds of arrest. We have been arrested in non-cognizable cases. Is the arrest without warrant warranted? Is it not warranted? And I begin with the quote from Frederick Douglass. Where justice is denied, where poverty is enforced, where ignorance prevails, and where anyone class is made to feel that society is an organized conspiracy to oppress, rob, and degrade them, then neither persons nor property will be safe. We have to look at the PMLA from the viewpoint that on one hand, we say that an under trial has several rights, including a right to liberty, except and should be granted bail, but in very serious offenses, that is on which will be only not given under two conditions: that if there is an apprehension that he will tamper with evidence, if there is an apprehension that he will abscond. And thus, except in very, very serious offenses, bail should be the norm. This aspect, while considering Section 45 of PMLA and Section 24, which deals with burden of proof, will have to be looked at by us. Now, several business houses and industries and businesses have come to a grinding halt. Several of leading persons in them have been accused of offenses by the Enforcement Directorate of money laundering. At the same time, the government of India is committed to ease of business. We have to see how the courts, as well as the administration and government, will balance the two while it looks at the PMLA and the provisions and legality of the PMLA. Let's look at the background. The Finance Act of 2019, which has culminated as the perhaps Fifth Amendment in a very recent act, which is the PMLA, is something which we need to look at. There's an old saying with regard to legislation, and which says that any enactment which should be made should be able to stand the test of time for at least 50 to 100 years without amendment. In the case of PMLA, we've had amendments in 2005, in 2009, in 2013, 18, 19. So the question here is, when will we have a wholesome act which will not need amendment after amendment as and when proceedings come into court? Now let's look at the background of money laundering. Why was an enactment like this needed? Why was it required that we have an act which provides for sanctions against money laundering? And the twin need which was felt, this was actually some 36 countries got together, the Financial Action Task Force, and two international organizations. And this is known also as FATF, the Financial Action Task Force. And what the task force met in, firstly, in the G7 summit, 7 of the leading countries met in July 1989 and said that an international body is required. Why is it required? There were two twin aspects. One, terrorist crime. How to ensure that terrorist crime and money which is used in circulation in terrorist crime is made accountable and brought to an end. Second, equally important, or perhaps virtually as important, is the drug money in narcotic trade. These were considered twin melees in which it was required that there should be international cooperation. It was to give effect to these resolutions of 1989, which were reiterated thereafter again in 1998 and in several other meetings, that it was decided to enact the PMLA by the government of India. Now the PMLA, the process under PMLA is twofold. On one hand, there is the adjudicatory process, the attachment of money, and on the other, there is the criminal process, offenses and trial under Section 3 and 4. The offense is under Section 3, the punishment is under 4, and there are scheduled offenses. Originally, there were very few scheduled offenses under the original act, but over a period of time, the offenses have been increased, and from included in this schedule have been offenses which were not part of the schedule as originally enacted. So insofar as a trial is concerned, if you see the left part, it shows that a complaint has to be filed. It's an ECIR, and at the same time, there would be, and this will be discussed further later, an FIR or RC in the predicate offense. There will be cases where there may be no predicate offense and only a prosecution under the PMLA. For example, you take a case where someone's been tried under Prevention of Corruption Act with government officers and other persons with whom they have been complicit. But the proceeds of crime would have gone on to other people who were not complicit in the predicate offense. They can be tried separately under Section 3 and punished under Section 4. It is in the nature of a complaint case which is filed. The adjudication process is a separate process. So there is what is called a PAO, a provisional attachment order, that can operate in the initial instance for 30 days and for a total instance of 180 before it's sent to the adjudicating authority under Section 8. The adjudicating authority then deals with the matter. Now, the money laundering cycle, this is what's the basis of
Geeta ma'am, you are not audible to us. Geeta ma'am, you are not audible to us.
Hello, we cannot hear you, ma'am.
Yeah, same. Actually, we are checking with the technical problem if there is any at the ma'am's part there.
Yeah, the screen is also, not visible.
Just I request all the participants to remain on the line. We're just checking with ma'am. I think there is some internet problem there. Anu ma'am, can you please check with Geeta ma'am?
Okay.
Ma'am needs to unmute. Maybe mute the
Ma'am needs to unmute. I think she must have pressed the mute.
Yeah, might be possible. I'll just check.
left side of the
Yeah.
screen, lower left side of the screen. एक बार tap करेंगे तो mute.
No, she hasn't unmuted.
So how should I call her on the
Yes,
screen?
yes. Anu ma'am, you need to call up
Okay.
because from our side it's all connected. Yes, ma'am. Can you hear us?
I can hear you. Are we on?
Yes, ma'am.
Yeah.
Yes, ma'am. We are on. We are on, ma'am. Yes, we have fixed the problem.
Okay. Thanks.
Please give me a second to fix the
Let me come back on
PowerPoint.
section 24
I'll
of
just get
PMLA.
Let me just get the
because
PowerPoint on.
I just want to discuss. You can start. I'll get Section 24 of PMLA.
Ma'am, sorry for interrupting. You were already you had that yes, the PPT on. Can we go to the same page when you stop? When we could not hear you, we could not hear you at this page. Yes, this one, please.
Okay.
Thank
Okay.
you.
Okay. Let me come back to this. I'm so sorry. So, as I was telling a little earlier, I think that predicate crimes, there would be a person, say, or a case where a person or several persons are accused with public servants and private persons of taking a contract, say a shipping or an airline contract, and in that there is a kickback. In the kickback, monies are received, and there is also a decision with the public servants that certain amount of commission will be paid. So there is commission, there is kickback, and this money becomes subject matter of a Prevention of Corruption Act case with certain offenses of the Indian Penal Code. There would be cases maybe of fraud, forgery, as well as offenses under Prevention of Corruption. That becomes a predicate crime. Now that money gets placed by being paid to the person from whom the contract is executed. After the placement, there has to be lots of layering to show that that money then looks as if it is legal money. So you would show that you've done a service, you have provided labor, you have provided a mechanism by which that money then becomes or looks as if it's legal money. It may be sent through Liechtenstein, it may be sent through Mauritius, it may be done through the Cayman Islands, it may be done through any various sources, because ultimately, after several layers of layering and service provisions, other provisions for maybe in a sense giving consultancy services, the person or a member of the family of that person will have to get back that money. So the money then becomes integrated into a legal system. So there will, in such a case where persons have committed predicate offenses, say there are 5 persons in the initial offense, but after that, to layer the money, another 5 persons help in layering or in forming companies or bodies or services in which they are parties to layer that money. Then those persons who have not been involved with the predicate offense would only be liable under section 3 and 4, but would not be liable under the predicate offense. So 2 cases go on parallelly. One is the criminal case in the main case, which is called the predicate offense, and then is the money laundering or the PMLA case. Much about this later, because 2019 amendment has brought in certain more provisions in order to prevent anyone from escaping the net of the law, even if one person is acquitted in a predicate offense. Question is, would he still be liable under PMLA? This aspect has still to be adjudicated by the courts. although both can continue simultaneously. But suppose you are an accused in a predicate offense, you are acquitted in that. To my mind, the PMLA offense almost always should collapse, even though it would continue because both have to continue in two separate streams, but should collapse. But the manner in which there has been amendments 244, 45 of PMLA in the 2019 amendment seems to want to carry them both as two separate streams, where the acquittal in the predicate offense would not affect the PMLA offense. Now, coming next to the next flow of events, there is an investigation by the police, the forest department. This would be, as I said, in the CBI criminal case, assuming. Then there's a charge sheet filed, RC, or an FIR. Then that goes to a special court. That court may or may not be the same court as the investigation by the ED. So the mandate of law envisages, and the whole issue at large envisages, huge amount of cooperation between India and the other countries, say Dubai or Mauritius, where India may want information, and these letter rogatories are answered. Earlier it used to take 5 months, 6 months, 7 months, several years, when one country or the other may drag its feet. Now it's a matter of hours and days when responses of letter rogatories are being received by India and ought to be given by India in the same manner, because there is this sense of mutual cooperation. Then once the ED investigates, then there is a ECIR, there's a special court, there's conviction in scheduled offense, and that is separate, and a conviction for the money laundering, which becomes a separate offense. Now, simultaneously, the ED does one other aspect, which I just said before. Section 5, there's a provisional attachment order, and that goes to the adjudicating authority. The adjudicating authority has to look at whether the parties are involved, whether it's a third-party transaction, what's the effect of a third-party transaction. Each amendment is trying to bring in within the net more and more people, and is also trying to enforce the attachment by amending the language of Section 3. Then there is confirmation of provisional attachment. Then it goes to the appellate body. So there is an appellate authority, which has been a retired High Court judge. And now come some of the salient features, which I've just discussed. So there is, apart from international cooperation, there is an extreme amount of cooperation inter-department. So the Income Tax Department will tell the Enforcement Directorate. The Enforcement Directorate will tell the CBI, and the SFIO. So all of them cooperate in a manner. Now the question is, while this cooperation is happening on one level, each investigation is also separate. So one body may actually feel a person's innocent, and another body, because they're doing their independent investigation, may actually feel, no, he is liable. Now, that cooperation between the agency, since there is no nodal authority, is something which would have to be looked at. There are special courts. These are of the Sessions Court level, which are set up across the country. Now, in order to find or get a disclosure of money laundering, the provision of getting more and more information from financial institutions, from banks, from intermediaries is become more and more stringent, and the requirements on these institutions and the burden on these institutions to do a due diligence is become extremely heavy. It's become so heavy that in a sense, it may actually affect their borrowing and lending and their activities, because as I said before, it is important that we have ease of doing business at the same time as making people accountable. Now, one of the aspects, which is the last part of this slide, statements recorded by ED officers are admissible as evidence. As all of you know, statements made to the police under the IPC are not admissible. Statements made to ED officers under Section 50 are admissible. Several cases where people have come and said, we were forced, we made a statement which was under duress, we were made to sign and make statements under duress, and these statements should not be admissible. Now, question is, this law, this principle of statements made to police officers not being admissible was one of the fundamental principles of rule of law, and that is why statements under 164 CRPC were admissible, which were made to a magistrate, but confessional statements or other statements made to ED officers, made to the police, were not admissible. This has in several economic offenses been changed, and in terrorist crimes. And this is again something which we have to look at with a very, very keen eye, because we have to ensure that the mandate of Article 21 and 22 is not violated. Now, some of the important provisions are 2(1)(u) of the definition of proceeds of crime, 3 read with 4 offense of money laundering, 5 provisional attachment of property, 8 confirmation of provisional attachment order, 24 burden of proof, 45 the bail provision. Much I will, after this, there will be much discussion on 24 and 45, which have been subject matter of interpretation of various courts. Now, what are proceeds of crime? This is on the next slide. And the punishment which is there is a term which may be less than 3 years, may extend to 7 years, also be liable to fine. Narcotic NDPS cases are different because the punishment is much larger, and therefore in PMLA they would be commensurate to the offense committed and the money laundered. Now coming to section 24, burden of proof. In any proceed relating to proceeds of crime under this act, in case a person is charged with the offense of money laundering under 3, authority or court shall, unless contrary is proved, presume that such proceeds of crime are involved in money laundering. So the sections which are important with regard to presumptions are 22, 23, and 24. Section 23 and 24 was subject matter of B. Ramalinga Raju, which is a well-known judgment where 23 and 24 and their effect was considered. In 23, and 24, what the court ultimately held was this. And this is what is different from normal burden of proof. So if we just look at what Supreme Court has said on burden of proof, it would be relevant. It's an old judgment before the coming into force of PMLA, 1973 to Supreme Court, SCC, page 808. It's Kali Ram. And what it says is there are certain cases in which statutory presumptions arise regarding the guilt of the accused. But the burden in even those cases is upon the prosecution to prove the existence of facts which have to be present before the presumption can be drawn. Once those facts are shown by the prosecution to exist, the court can raise the statutory presumption, and it would, in such event, be for the accused to rebut the presumption. The onus, even in such cases, is not as heavy as is normally upon the prosecution to prove the guilt of the accused. Now, what we are looking at is Kali Ram still says sanctity of burden of proof. Prosecution still has to show a lot. Rama Raju was a case which dealt with section 5 and 8 with regard to attachment orders and provisional attachment. And the question in that case was, can there be a reverse burden of proof even in attachment orders, even under the civil law? And would it be inure only for trials, or would it inure even at the inception? And this is what was said in that case. The burden of proving that the proceeds of crime are untainted property onto persons accused of having committed the offense under section 3 is not confined to the trial of an offense under section 3, but operates to attachment and confiscation proceedings under chapter 3 as well. A judgment of the Gujarat High Court, Division Bench of Gujarat High Court in Rakesh Manikchand Kothari, which was a case pertaining to bills of entry for diamonds, for taking diamonds out of the country, and whether diamonds were actually being sent or only bills of entry were being manufactured or fabricated. Again, said the same thing, that such burden of proof is changed even in cases where there is an attachment order, and it just does not inure only to criminal proceedings. In Ramaraju, the court further went on to say, the presumption enjoined by 23 is clearly a rebuttable presumption, presumpto pro tantum. In Izhar Ahmed versus Union of India, it refers to that judgment by Justice Gajendra Gadkar. In a Constitution Bench judgment, the court said presumption in its largest and most comprehensive signification may be defined to be an inference, affirmative or disaffirmative, of the truth or falsehood of a doubtful fact or proposition. Quoting with approval the statement of principle set out in the Principles of Law of Evidence by Best, the Lordship observed that when the rules of evidence provide for raising of a rebuttable presumption, they are merely attempting to assist the judicial mind in the matter of weighing the probative or persuasive force of certain facts proved in relation to other facts presumed or inferred. So several judgments of the various courts have held that the presumption is turned around. But there is, according to me, the Supreme Court still has to give a definite pronouncement on it. And the words of Kali Ram's judgment, the fact is prosecution still has to establish its case before the burden of proof is twisted and turned around. Thus, if we come on to the next slide, this is the normal law, 101, 103, 106 of the Indian Evidence Act. And unless and until an exception is created, the burden is on a person making any claim or asserting a fact. This is in civil law. In criminal law, that burden and that presumption of innocence has to be varied with a very jaundiced eye and very clear look. Now coming to section 45 of PMLA, the reason 45 is such a vexed question, even though it has now been settled by the Supreme Court in Nikesh Tarachand Shah versus Union of India, 2018 judgment by Justice Nariman's bench. Why it's such a vexed question is, if I read out the provisions of section 45 as it existed before the amendment of 2019, it would be relevant. And it says, notwithstanding anything contained in the Code of Criminal Procedure, no person accused of an offense under this act shall be released on bail on his own bond unless, and it goes on further, unless the public prosecutor has been given an opportunity to oppose the application for such release. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offense and he is not likely to commit any offense. And then there are exceptions created with regard to persons who are a woman under 16 or an accused of less than offense of 1 crore. Now the question here is, when the matter came in Nikesh Purachand, when the matter came before the, doesn't matter. When the matter came before the Supreme Court, the Supreme Court has ruled that the CRPC section 65 provides that the CRPC section 65 provides that CRPC, the section 65 of PMLA provides that the CRPC shall apply. Now, if CRPC does apply, this is one aspect. The second aspect is, can a go-by be given to the right to the fundamental rights of a citizen or an accused by reverting the right of anticipatory bail by bringing in these two twin conditions. These twin conditions were struck down by the Supreme Court, and subsequent to that, an amendment has been brought in 2019. That amendment seeks in its own way to override the effect of Nikesh Tarachand, and in a sense, it has the only language that it adopts is saying that under this act. So once it brings the language under this act, it is trying to restore the position prior to the Supreme Court judgment of 2018. Question is that permissible? It is my view, and it is the view of several courts, that this is not permissible, because this in fact has been tested by 3 high courts, the Madhya Pradesh High Court in Vinod Bhandari, the Bombay High Court, as well as the Delhi High Court. The Delhi High Court, citing the Bombay High Court as well as the Madhya Pradesh High Court, Vinod Bhandari's case, says that once Supreme Court has ruled on it, just by saying under this act cannot have the effect of setting aside the fact that the Supreme Court has in fact set aside these 2 provisions as being illegal. Based on this, several persons under PMLA have been granted bail, anticipatory and regular, after looking at the Supreme Court precedent of Nikesh Tarachand and the amendment in 2019 of Section 45 has been held not to affect the ruling of the Supreme Court on Section 45. Another important change under Section 19 that has been sought to be introduced is in Section 44. And that again is because there have been several petitions which are saying that if the trial in the predicate offense is over, then the trial under Section 3 and 4 under PMLA should also not be affected. The question will be, would this, firstly, one of the prime issues which will come up before the courts is, are explanations good enough to amend a provision which has already been interpreted by the courts? Second, is it good enough to operate with retrospective effect? Is an explanation able to control the main parent provision? And to my view, this may not stand the test, may or may not be able to stand the test of judicial scrutiny. Time will tell. Now, coming to seizure of property under PMLA, as well as the applicability of CRPC. So 17(1)(a) of the PMLA and Section 102 of the CRPC, both of them operate slightly differently. While one it operates indefinitely, Section 17(1)(a) does not operate indefinitely. Now, I'm skipping the next slide. And I am now coming to 12AA of the 2019 amendment, which mandates authentication of a client specified transactions. These include requiring every reporting entity to take additional steps to examine a client's ownership and financial position, including sources of funds of the client prior to the commencement of each transaction. The focus of the amendment is to enhance due diligence conducted by the regulators, requiring reporting entities to take additional steps to record the purpose behind conducting the specified transaction and the intended nature of the relationship between the transacting parties. In cases where the client fails to fulfill the conditions as stated in the provision, the reporting entity shall not allow the specified transaction to be carried out. Thus, the noose gets tighter and tighter. The mandate and the requirements become more and more stringent. The requirements on banks, financial institutions, on individuals become more and more difficult of compliance. Now, one of the aspects which has been subject matter of challenge in several judgments, including in Gautam Khaitan, in the Augusta Westland, in several other cases, was, can a supplementary complaint be filed? Now, while 173(8) provides that a supplementary charge sheet can be filed if permission sought, there is no similar provision of supplementary complaint being filed. And in several cases by the Enforcement Directorate, it is indeed unfortunate that people are arrested and yet thereafter supplementary complaints giving their complicity are filed again and again without having taken permission of the special judge beforehand, without taking leave of the special judge. And can so many supplementary complaints against pre-existing accused be filed? I'm sure there could be grounds that they could be filed against new accused. Question is against old accused. And the question again is there a provision for filing supplementary complaint? Now, in order to cover this lacuna or this infirmity in the law, an attempt is being made to amend, which is still to stand scrutiny, but that a supplementary complaint can be filed. In R. Subramaniam versus Assistant Director in 2018, this issue was taken up by the High Court in Chennai, and it said that a supplementary complaint can be filed. Now there is an amendment of 2019, so that will have to be looked at. Now, coming to the independence of proceedings, I've already spoken about that when I spoke about an earlier slide. I was wanting to talk about PMLA and IBC. This issue has been a very interesting issue. And one of the issues raised was that there were SARFAESI proceedings against Axis Bank. There were IBC proceedings. There were PMLA proceedings against main accused, and Axis Bank rather had filed proceedings under SARFAESI, not against. And the question was, they had already taken collateral securities. They had taken those securities not knowing that the money could be alleged to be tainted money. Now the question was, would Axis Bank have primacy, or would the effect be that the money could be attached by Enforcement Directorate? And Justice Gauba, by a judgment known as Axis Bank versus Enforcement Directorate, has ruled to the effect that the lending bank, which did it innocently and had collateral security, had security of the amounts which were later being alleged to be monies which were tainted, would have supremacy and primacy. Now, in another proceeding where the issue between PMLA and the Insolvency and Bankruptcy Code came up before the appellate tribunal, and the appellate tribunal said they operate in different spheres. But I don't think that they can only say they operate in different spheres. It needs to be looked at. And this is what the Delhi High Court has done. So that's interesting. And that's what a third-party claim, so basic tests of third-party claims, how third parties' losses, which are bona fide, and even though the Section 3 and 2 explanations have been added in 2019 in order to broaden the net, The question is, how much can we enhance that net? How much can we broaden the net? Now, as you know, there are several cases which have been filed recently under the PMLA. There are cases against directors of Island Affairs. There are cases with regard to Bhushan Steel. There are several proceedings which are pending. As in several of them, bails have been granted. In some, bails have not been granted. In the case of two of the directors of ILFS, the Bombay Sessions Court, taking into account COVID and the fact that there are low immunity health issues, the Sessions Court in Bombay has granted bail. With regard to Mr. Rana Kapoor, bail has not been granted, even though he is an asthma person with low immunity, according to his allegations. The ultimate aspect which we have to look at is how are the courts dealing with the cases. And it would be remiss if I conclude without referring to a judgment of the Delhi High Court in Rajbhushan Om Prakash Dikshit versus Union of India, which was a writ of habeas corpus by a person who was taken into custody. In most of these cases, I did read out Article 22 and said that reasons of arrest have to be given. In most cases, the accused have come to court, the petitioners have come to court and said reasons have not been given to them. And this was one of the allegations which was made by Rajbhushan Om Prakash Dikshit. Now, Income Tax Department had conducted a raid on Sterling Biotech, and the petitioner had asked for relief. Now, there was a Prevention of Corruption Act case made, but what was said was that the FIR which was registered was under 420, as well as by several other sections like Prevention of Corruption Act. Now, the question that several issues came up with regard to 44 and 45 of the PMLA. And one of the issues was, is it cognizable or is it not cognizable, as I had told earlier? Now, when discussed in Parliament at that time, Mr. Chidambaram, at the time of introduction of 2005 amendment, had said it was non-cognizable. Now, by way of the explanation, but the head note continued to call it cognizable. The question is, and this is an interpretation by judgments of our courts, which say that a head note cannot govern the main section. So once in Parliament, it had been introduced by saying it would be non-cognizable. The question was, would it be or would it not be? And the court thus compared 45 and then granted relief based on Union of India versus National Federation of the Blind, where it said that a heading of a section or marginal note cannot be used at when the section itself is unambiguous. One last word on 45. Not the last has been heard on 45, even though the Supreme Court has ruled, because there are similar provisions in SFIO. There are similar provisions in Section 37 of NDPS. There are similar restrictions which are being sought to be placed under 212 and 447 of the Companies Act. Question will be, will not Nikesh Tarachand govern the interpretation once Supreme Court has laid it in similar circumstances under the PMLA to those enactments also. Thank you.
Thank you, ma'am. It was such a great session.
Thank you. I'm glad you liked it, Kadambari.
Of course, it was very lucid. It was very clear. Thank you so much.
Thank you. Thank you. Does anybody have a question, or do we have to go on to another session with?
No, we can continue in this only. I'm again requesting any of the listeners, if have any question, they can please ask. Geeta ma'am is waiting the questions. If you have, you can just start with your mic.
Yeah, I saw one question which has come on my screen. Section 50, what section are the statements admissible in PMLA? Well, it's section 50. So that's one aspect on which the question has been asked, and I can give an answer. PMLA a continuing offense? Now that's what is being sought to be done by section 3. And that the amendment to section 3 in 2019. And the view that is being taken, it is a continuing offense, but I believe that when it is tested in a court of law, the question will be still requiring determination, because the moment that you make a continuing offense, then one, you're getting rid of the retrospectivity aspect. Second, you're getting rid of any limitation. So even though the court says so, even though the amendment says so, I believe the courts will test it.
Thank you, ma'am. Ma'am, there is another question which is coming up. It is like, which would have an overriding effect between IBC and PMLA with respect to attachment of property? If you can hear me, ma'am.
So Axis Bank was actually, the case was a case of attachment of property, and the citation, if I have it, one criminal, no, it wasn't. It was a criminal appeal, but in any case, it dealt with that also. And it's criminal appeal 143 of 18 and criminal miscellaneous application 2260 decided on April 19. But the question is, NCLAT in its has said that none has primacy, they coexist in their own sphere. But to my mind, all that this seemed to say is the IBC, PMLA, if the banks or third-party organizations have put in money, then that amount, they will have primacy if they were bona fide loanees taking this as a mortgage without knowing that this could possibly be subject matter of any proceedings. Now, there's something else which was coming in my mind with regard to this, which I've just given you. The name of that judgment is Rotomac Global Private Limited, which I was referring to. So that's how NCLAT, there is, what was coming to my mind is that the ED, I believe, has said, without quoting anyone, in Vijay Mallya's case, that if it's the claim of public sector banks, we will respect them. But if it's the claim, say, of a company like Diageo, which has said, put its claim as a first claim, that would not be given primacy And that's what the ED stand is going to be.
Thank you, ma'am, for this. Yes, Rajat, I think you have some question.
Good evening, ma'am. Yes, ma'am. Good evening, ma'am. I have a query. Like, if you will see section 3 of the PMLA, it says that any person guilty of offense of money laundering, if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party, or is actually involved in one of the following process, that is concealment, possession, acquisition, or use. And thereafter they use the word and. If you will see the section 3.
Yes, let me get out the amended section 3 for you.
See, if you will if you will see the section 3, ma'am, they are using the word and before projecting.
Yes.
But if you will see the explanation, what they have done, they have used the word or instead of and.
Yes, yes.
So, like, the impact of this is this: if I do either of the activity, whether it is possession, acquisition, or use, or projection, I will be guilty of offense of money laundering. But if I will see the definition under section 3, it says that either one of the activity and projection is a must.
Yes.
Because there is a word
it
and.
Can't be. The or will probably be struck down by a court, because you cannot have an explanation which becomes larger than the section itself.
And the second, I concur with your views, ma'am. Secondly, thing, the way they have made the section continuing with the explanation, and there are a lot of judgments by the High Court wherein they have said that the offense of money laundering is not a continuous offense. Once the stage of integration is done prior to the coming of the act, the offense is over.
That's
now by the way of explanation, can they do that? Will it stand the test of the law?
To my mind, because the challenge in most writ petitions and 482 petitions and 226 and other petitions have been with regard to this aspect, one of these aspects, that they are trying to apply it retrospectively. It is in order to get out of this restriction that they are trying to have an explanation saying it's continuous. To my mind, it will be very difficult for them for it to stand through the test through an explanation alone.
And ma'am, like, by the 2019 amendment, what they have done, they have deleted the proviso under section 17 and section 18, that for such they it was prior to that there should be some ECI, or they should inform the magistrate before prior to search. Now by 2019 they have deleted that provision. They can come and directly search. So what's your view over that?
So this could be a subject matter of a writ challenging, including under 14, 21, 22, to my mind. Because the very ethos of the rule of law and criminal jurisprudence would require that there should be something which should be before you before further action is taken.
Okay, and the last question is that they are bringing the changes in the PMLA through Finance Act. If you will see in the 1817, 1819, the finance bill is a money bill. It doesn't have to go through both the houses. So whether it should stand the test of the law?
This is definitely going to be a subject matter of challenge, as many things which have been introduced through Finance Acts, and which can be argued that these are matters which cannot be introduced through Finance Acts. So there are several, this challenge is a common challenge which is being placed in courts, and which to my mind is very real and may not be able to stand scrutiny in a court of law. Can we have the last question?
Yes,
thank you, ma'am.
Good evening,
yes.
ma'am. This is Siddhi side. Ma'am, I just have a small query for you. Hello?
Yeah, I'm hearing.
Yes, ma'am. So, ma'am, my question is on conjoint reading of section 2U and section 3 of the PMLA. Is it correct to say that money laundering is an independent offense?
Yes.
So, ma'am, there have been various judgments of Delhi High Court which have been challenged further also, which they say that if a person is acquitted for a scheduled offense, then will the offense under section 3 will still continue? The proceedings of PMLA will this still continue?
So there is no judgment as such yet on it. The way the explanation 244 is being sought to be made is to try and say that they should continue to parallelly, and therefore one acquittal in one should not. That's what I said when I was speaking, that this is a question which is still to be determined by the courts.
Yeah, ma'am, because the judgment that I was referring to is Rajiv Chinana versus Director of Enforcement, in which the High Court, this is a single bench judge judgment, which they said ki once the offense, the person is acquitted under for the scheduled offense, then the trial for section 3 will not survive.
No, I haven't come across that judgment, but according to me, that should be the legal view. But then now, after the amendment, one would then have to have the section 44 1G struck down, according to me, because that's how that is envisaging them to continue independently, and that continuing notwithstanding.
Thank you so much, ma'am.
Geeta ma'am, can you hear me?
Yes.
Yeah. Hi, ma'am. First of all, thanks a lot. Sincere thanks for such a wonderful, brilliant lecture, ma'am. It was very extensive, dealing with a very complicated and complex subject. Ma'am, would it be wrong to say that this act is in the process of evolution? I mean, it has seen so many changes, amendments, challenges, that it is still not settled. It is still unsettled.
So according to me, laws should not evolve in this manner. It is clearly in the process of evolution if there are 4 or 5 amendments in last 14, 15 years. But according to me, and this is something which most lawmakers will say, that when you make an enactment, then that enactment should be able to stand the test of time for at least 50 to 100 years. So that, therefore, the fact that it is being amended again and again is not a happy fact. And the second aspect is that what is the original purpose of the act was to attack terrorist crime and narcotic crime and the monies of those which were in the market. So that's what it was originally meant for. We've actually expanded the law and we've enlarged it. So
almost like an afterthought, ma'am, almost like an afterthought to try to cover the ambit, within the ambit, larger offenders or larger offenses.
So what staff wanted was, and what the European Union and both the organization, international organizations had recommended, was an attack on these twin illegal monies, tainted monies, which are circulating.
Yes.
So I can't say, yes, it seems to be evolving.
Yes. Thank you so much, ma'am. Pleasure.
Thank you.
Thank you, Anu. Thank you, Anu ma'am. Thank you, Geeta ma'am. I think we all have been very glad to hear you via this platform. And on this very difficult subject, it has been made very easy by you to understand all through modes of the slides. I think those were very wonderfully made, and in very short span, you have explained the whole act. And we from this platform, from Lecture Series on Law, and we all are very thankful to you. And from the side of all the listeners, ma'am, I'm once again thanking you for this wonderful lecture today on prevention of money laundering. Thank you so much, ma'am.
Thank you.
Thank you.
Thank you for hearing me.